Sanjay and I can moderate.
I won't make any comments about specific real estate companies then.
That's a good plan.
Is the
Especially
company,
they're realtors.
hey, real quick, because I've got a call after this today on.
We're live, John, just so you know.
I know that
There's
same
participants.
company. Are they members?
Yes.
Oh, yeah.
Okay. That answers the question. So they're compliant. They have to comply with your rules, your photograph rules. All right. Well, hello, everybody. So Ed, you're going to tell, well, when you get to a certain number, there's going to be around 100 probably. So.
Well, I've got your bio, so I'm happy to introduce you. How are questions coming in the chat? How do you want questions to come in?
Yeah, we can put them in the chat, and Ed, I'm assuming that you will go ahead and monitor those.
I will go ahead and monitor the chat. Just so you all know, if you're looking in the chat for some reason, after I get through a series of questions, I put X's as a reply. I'm not kissing people. I'm just letting myself know where I left off. So if you see that, now you know why I do that. I've been doing this since the beginning of COVID, and I've got these little nuances, but I'll be doing that. And then do you all want to make a few introductory remarks before we open it up for questions, or before I start doing questions?
I've got some time. I know I've heard Ed, and I really like, oh, by the way, hi Sanjay. Good to see
Hey,
you.
I know I had something else. I couldn't join until right before.
Glad you got out of jury duty.
I know I had to do the reporting yesterday, and then since I wasn't called, yay.
So what we like to do is have Ed go first, because some of the comments that he's going to make will flow right into what Sanjay's got to say about the legislation. And I know there's some talk about some things with the buyer broker, issue and whatever else you got to talk about. And then I'll follow up with, a potpourri of, useless information about how not to get sued. Because we've been getting some crazy, I don't know about you, Eddie, but we've been getting some crazy calls lately. It's like, seriously, you don't know this?
I got 2 transactions right now. It's driving me crazy. So
People
I hear you.
think that the TDS is a contingency. I'm going to lead with that, because I can't tell you how many calls I've had lately, and arguments not arguments with me, but with the 2 brokers about, well, you waived your contingencies. Well, the TDS, those kinds of discussions, and the deposits, and it's just, it's petty stuff, but.
Actually, John, it would be great if you would address, because it is stated in the purchase agreement now, whereas waiver of contingencies has nothing to do with your statutory cancellation rights. And of course, some sellers have to do TDSs, some don't. So what you say to your buyer with a non-contingent offer as to whether or not you can cancel or not, because you don't know for certain if that seller has to do a TDS or lead-based paint or FHDS or anything like that, that's really important, because it is confusing, because people confuse cancellation rights under statute with contingencies under the contract.
Well, and so when I'm going to revise, the RPA program. I know you're going to be teaching it again too, and because the new contract comes out probably October, for distribution in December, the new RPA, where they're going to be. Well, I'll go into all that when I talk, and then we'll talk about how we think people should handle it. But I know that it's after 12, so I'll shut up and let.
Yeah, let's go ahead and get started.
Okay, great. Laura, do you have anything to say? Or otherwise, I'll kick it off. What do you want to do?
Well, I do want to promote, John Giardinelli is teaching a property management class on September 12th. And I would like to promote that. It's John, do you want to talk a little bit about that class real quick? Because I think it's very important.
We were supposed to do it last week, and Laura was kind enough to allow me to continue it on into September, because frankly, so much is changing, particularly in Los Angeles County and elsewhere, that I asked, let's put it off a little bit, kind of get a sense of where the legislature is going and where the county and the city are. But yeah, it's going to be. I'm going to limit it this time. I'm not going to do a property management class with everything covered. We're going to zero in on eviction and some other stuff. So, and frankly, it emanated from a client of mine And I'll talk about that when I do my presentation. So yeah, it's a good class. I'm hoping it's a good class. So we'll be doing that in September. So thank you, Laura, for letting me continue it.
Sure. And then the other thing is we're having a general membership meeting on October 6th. And Gov Hutchinson is our keynote speaker for that. And that's going to be in person at Los Serranos Country Club from 11:30 to 2.
It's too bad you're not doing it by Zoom. I'd like to hear what Gov has to say.
Okay, so go ahead. It looks like we do have one hand up already. That's Marion Prophet. Marion, do you have a question?
Marion, you just muted yourself. Marion, you're muted.
Hi, I'm really sorry. I'm on my phone and I can't seem to get my hand down.
Okay,
So-
I'll put it
Okay.
down for you.
Put your hands down.
Oh, hi, Marion.
Hi, everybody. Sorry about that. Thank you.
Sure, okay. All right. It's all
Okay.
yours, guys.
Okay, great. Well, my name is Ed Estes, and I am a full-time real estate professor at Mount San Antonio College. Although I am a member of the bar and I am a real estate broker, I do not practice. I have been selected by your general counsel, John Gardnelli, to host the forum and serve as a moderator, which I'm always enjoying to do. Let me go ahead and introduce some of our panelists. First, Sanjay. He is the Senior Vice President of Government Affairs for the California Association of Realtors. He's actually headquartered in Sacramento, where he lobbies on the behalf of associations and supervises the work of CAR's policy staff. But prior to working with CAR in its Government Affairs Division, he worked in CAR member legal department in Los Angeles. He is also a member of the State Bar. Edward Zorn, or Ed Zorn, Ed Zorn, we have two Eds here, making it even more confusing. He is Vice President and General Counsel of CRMLS. He has over 25 years of experience. His practice in law prior to joining CRMLS focused on representing local realtor associations, brokers, developers, and landlords. He holds a broker's license since 2002. He has owned and managed both residential commercial brokerage firms. He is an active real estate investor and has served as a mediator and arbitrator for the American Arbitration Association. And finally, somebody who needs no introduction, but he will be introduced nevertheless, is your general counsel, John Gardnelli. He's an attorney, of course, who specializes in real estate and business law with an emphasis on broker representation and broker defense. He represents 9 realtor associations. That's a lot of realtor associations, including tri-counties, with a cumulative membership of over 40,000 throughout Southern California. So the way we're going to handle this is if you could all put your questions in the chat, I will be, I wouldn't say filtering those questions, but I will be kind of interpreting those, because sometimes we get questions that may not be complete, might need some missing information. So I'm going to be drawing on my 44 years of experience in real estate so that things come out as clear and as concise as we can as we get through this. It just seems to work better if the questions can come from me, but we will answer all questions. And before we get to that, as you're getting ready to put your questions into the chat, I'd like to ask our panelists to begin with some introductory remarks. And maybe we can start with Ed, go to Sanjay, and then John. As they're giving their introductory remarks, please put your questions in the chat. I will be monitoring the chat and then sending the questions to our panelists. If you would like a specific panelist to start with your question, just put in there, question for John, question for Ed, question for Sanjay, and we will lead off with that. Although all of our panelists are welcome to weigh in on the questions. However, what's worked well in the past is if we have a complete answer by one of the panelists, we may not have all 3 panelists weigh in. Maybe it'll be just the 1, the 2, but of course, if somebody has something to say, we welcome their contributions. So why don't we start with Ed, our CRMLS legal guru, who probably has all kinds of comments, stories, and warnings to share with us. Ed?
Yeah, thanks, Ed, and I appreciate the opportunity to come. I think I've been doing this for probably almost 10 years now here at Tri-Counties, coming up and getting to do these panels. They're very enjoyable, so thanks for having me back. Want to talk a little bit about what's happening in the MLS space, and specifically on the legal front. It's extraordinarily busy. There are lawsuits all over the place. Most of these lawsuits involve the National Association of Realtors, and they kind of come in a couple of different flavors, but all of them deal with what we do in the MLS. There's a group of commission-focused lawsuits that are attacking the way that the NAR policy has laid out how we share commissions using the multiple listing service. And so I want to give a little bit of update of what's going on with those lawsuits and what does that mean for you guys, like boot on the street moving forward. And so the first one I want to talk about is a case called Sitzer out of the state of Missouri. And it's against NAR. And then they also named in the state of Missouri, like the top 8 or 9 individual brokers, as well as some large franchisors. And that case alleges, from the perspective of sellers, that sellers are overpaying in the amount of fees that they're charged by real estate professionals by the amount that's being given to the buying side of the transaction. And the argument is basically made that because we share commissions in the MLS, and this is set up by rules, so it's a group of competitors, meaning a bunch of brokers who run an MLS, coming together and setting up rules saying you have to offer some kind of compensation in the MLS. Now, everyone acknowledges that there's no requirement of what that number is. And in fact, it's CRMLS. At any given moment, we have about 500 listings that are offering $1 or less. You can put 1 penny as the offer of compensation in the MLS. So we don't regulate the amount. But this lawsuit alleges the process of encouraging this sharing of commission in the MLS creates a situation where the sellers are compelled to offer a certain level of compensation to the buyer side, or their properties won't be shown, right? They'll be steering away from lower commission type of properties, and the sellers will be damaged. So they have really no choice. They gotta, to kind of play in the sandbox, they gotta pay this extra money to this thing called a buyer's agent, even though the buyer agent doesn't help them. And so that's kind of the allegations of that claim. The status of the case is that it has now been officially certified as a class. And what that means is it is a large case in Missouri. It is all sellers who used any of these brokers. So it's about 50% of the closed sales in Missouri over a 4-year period. And the claim is the entirety of the buying side commission that was paid. So the case is somewhere around $600 to $700 million is kind of the thumbnail on that. And the judge in that case wrote a very detailed analysis as to why he thought the case was appropriate for class certification. And that is moving forward. This judge moves fast. And this is going to go to trial in February 2023. And really, those of us that kind of are watching this process unfold are very confident that that trial will happen if the case doesn't settle before then. There's another case that's even bigger in the Northern District of Chicago, exact same claims, but this one is much broader in scope in that it includes 20 separate MLS markets identified. So it's on many different states. Now, interestingly, they did not name any MLS in California. So it doesn't involve the state of California. It's called Morel. It is just up for class certification right now. The judge is receiving the paperwork. NAR filed an excellent opposition to class certification. I thought it was very well crafted and highlighted some really strong arguments. I wish they would have made a couple of additional ones, but I understand maybe why they can and cannot, considering some other litigation I'm going to talk about. And that's moving forward for class certification. That one, if it's certified, will probably be a $4 to $5 billion case. That's billion with a B, okay? Because it's in 20 different marketplaces. So, and again, it's same case, alleging that sellers overpaid by the amount they had to pay for the seller's commission. So these are industry changing lawsuits, right? If one of these hits, how we do business is going to be different. And keep in mind that these lawsuits also have a request for the court to issue injunctions to prevent NAR and us as MLSs from enforcing these rules and allowing commissions to be in the MLS. So that's one side of commission cases, right? Seller side. As you all know, commissions go a couple different ways, right? There's also a buyer side of commissions. Well, not to be left out, there's a group of attorneys who've also filed a lawsuit on the buyer side, representing buyers. And interestingly enough, it's in the exact same, in front of the same judge in Northern Illinois as the Morrell case. And she has recently ruled where she dismissed the case against NAR. NAR brought a motion to dismiss and argued that under the rules of antitrust, a buyer, since they're an indirect purchaser of the product, of the service, that they don't have standing to sue. And the court agreed with that argument and dismissed the case. Now, on the buyer side argument, it goes like this, that buyers pay the commission, right? The commission is buried inside of the purchase price. And as a result, the buyer is actually the one taking the check to the escrow to pay that commission. But think about it. The buyer doesn't get to negotiate the fee that their agent is paid, right? It's this fee that's going to go to the buyer's agent is determined in a conversation between this person called the listing agent and the seller, and the buyer has nothing to do with it, but the buyer has to pay the fee anyway. And so the allegation from the buy side is that's unfair. Buyers should directly negotiate their own terms of what they want to pay for services rendered to them. And they shouldn't be forced to pay what this fee negotiated between, again, the seller and the listing agent was. And so that's the flavor of that buyer case. Now, the buyer case was dismissed. However, about a week and a half ago, the buyers did file an amended complaint. And in that amended complaint, in addition to NAR, which they'd already sued, they alleged violation in 25 individual states, citing 25 individual state antitrust laws, including California's, right? So it is probably enough to get through the next motion to dismiss. So the buyer case may be with us and stay kind of moving forward. So there's a lot of energy right now attacking the way we do commissions inside the MLS. And that is even furthered on from, and maybe Sanjay may get into a little bit, it's more on the legislative side, at the federal level, that Biden has issued an executive order. And in that executive order, he specifically calls on the FTC to investigate and to consider rulemaking with regard to the practice of real estate brokers tying their commissions together, right? It's a direct reference to this practice of sharing commissions in the MLS is the exact thing that Biden has asked the Federal Trade Commission to investigate and make rules about. Now, keep in mind, we just had a lawsuit where the buyers were kicked out of court. If that happens again, does that create the political motivation to say, hey, the buyers have no recourse? We need to come in and do some type of federal level, rulemaking, getting commissions out of the MLS system and this sharing. So those are a couple of flavors, and I know we want to get to questions, and so I just wanted to kind of introduce the topic. In addition, in one MLS in Seattle area, Northwest MLS, in response to some of these issues, has issued some rule changes very recently. Now, Northwest MLS is not affiliated with the National Association of Realtors, so they do not have to follow any of the NAR rules at all. They can do whatever they want. And what they decided to do was change how commissions work. So starting in October, under their rule set, commissions will no longer be made as an offer from the listing broker to the buying broker in the MLS. In the MLS, it will be an offer from the seller to the buyer's broker. And then what they are also doing in Northwest MLS, they actually also control the forms. So the most forms in the state of Washington are actually created by Northwest MLS, not the state level association like we do here. and they're changing their version of the RPA. So there will be a specific section about commissions in the purchase agreement. And there'll be a section that says buyer accepts the offer made by seller for a contribution to the buyer's agent fee, or, and then the box can be checked that says, see the addendum. And the addendum will allow for rejecting that amount, asking for more money to go to the buyer's agent, rejecting the amount and asking for less money to go, or saying, I don't want any commission at all. I'm going to pay my own buyer's agent as the buyer. I don't need any help. Thanks. No thanks. And nothing. So the concept here is that between the buyer and the seller, the amount of fee will be paid directly to the buyer's agent. Now, what this is creating in Washington is a situation where having a buyer representation agreement between the buyer's broker and the buyer is absolutely critical, right? Because this whole conversation about how much the buyer is going to get paid is directly related to your contractual provisions in making an offer. And so, the state of Washington is looking at various options, including potential legislation. I'm actually meeting with a presidential advisory group in Washington state on Monday to talk about these issues with them as they're kind of trying to decide what to do. So a little bit of a flavor of what's going on the MLS. I guess in summary and closing out, everybody on this call, you all need to get ready for no commissions in the MLS within the next 18 months to 2 years, right? We will probably not have commissions inside the MLS one way or the other. And so that's something we need to kind of prepare for. By the way, guys, not a big deal. I'm a commercial practitioner. I've closed probably 50 commercial transactions. There is no commercial MLS whatsoever, no offer of compensation whatsoever. And you know what? I've gotten paid on every deal I've ever done. And 90% of the time, that money came from the seller, whether I represent the buyer or not. And so in the commercial world, we do almost exactly what Northwest MLS is proposing, and we all get paid. So don't think this is the end of the world. It's just a slight little alteration in how we do our work, and it'll be fine. So I guess that's enough for opening comments.
Okay, thank you, Ed. I appreciate that. Sanjay, why don't you go next?
Thank you, Ed. So I'll touch on two things, the sort of areas I get a lot of questions about. So first, I'll touch briefly on politics. As you know, I always like to give a sense of the political environment in which we operate in California. As you know, every executive office is held by the Democratic Party, as well as supermajorities in both houses, with a much narrower supermajority in the Senate. That makes for a challenging environment, but we've actually had a very good legislative year this year in being able to stop, and I'll touch on some of these in a few minutes, stop a lot of really bad legislation from moving forward or securing amendments to make them not bad. As far as politically, what does it look like based on current polling? We live in a very dynamic world. Roe versus Wade. Will Trump announce for presidency before the election? There's lots of factors, but generally speaking, based on the polling, not much is going to change in California. Politically, the situation is likely to remain status quo. The one race where that might be different is actually the state controller's race. That is where it's Chen versus Cohen, and there is a Republican who actually has a chance at winning an executive office in California for the first time in, let's say, 20 odd years since that's happened. Part of that is he has received endorsements. The LA Times actually endorsed the Republican in this case, saying this is not a position that has to do with social issues, etc. It's better to have somebody from the opposite party in that role. And so that might have contributed to his lead. But so just to give you a favor of the landscape. But the reason I always like to do that is because people read about what might be happening nationally and they think, oh, red tide. That red tide breaks on the left coast. So so that's where we are politically. In terms of our policy goals and in terms of legislatively, we have had a good year. This has been, and some of you may have seen if you were at the legislative committee, this has been a year of a lot of no. CAR has basically taken a lot of positions that we just oppose a number of bills. We have not, normally, if we think we can reach some sort of accord, we'll suggest amendments to go to a neutral stance. But this year has been a lot of no. We've just been opposing a lot of bills with straight no's. We've had a lot of what are key contact red alerts, one or two actual red alerts. Some of you might be in districts and you're like, I haven't heard anything about any red alerts. That's because those tend to be very targeted to specific seats, specific members of the legislature. But basically, we've been able to stop a number of very bad bills, especially, not surprisingly, in the rental arena. I do get a lot of questions about whether we're expecting any kind of rent moratorium on the state level. The answer is no. Most of you are in LA County, you know LA County has its own versions of this. One of the reasons why, actually, which is not a great reason, that we have not seen a state moratorium is locals that had stronger moratoriums than the state wanted to make sure theirs went into place. So San Francisco, Los Angeles, and a lot of those areas were like, we don't want the state moratorium. The state moratorium isn't the way we want to go. And so they actually did not support that. We opposed, of course, any kind of state moratorium, and that was not going to move forward. As I said, the vast majority of our no's have been in the rental arena and has been a good year. The only downside about that is I honestly believe every one of these bills will come back next year and we will have to fight them again. So statewide rental registry will probably come back. Attempts to stop consumer credit checks on subsidized housing is likely to come back. All these kind of, some of you might live in areas with TOPA, COPA, which are first right of refusals on investment properties, including single family homes by community organizations or the tenant or nonprofits. That has been stopped basically successfully everywhere but San Francisco. And that has been, even in Berkeley, they were able to stop that. But variations of that will most likely return. Part of this, quite honestly, is they push too far. And so it makes the process really drawn out. So we're likely to see all of those bills return, but we're going to be fighting all of them again, is what that means. We've also seen attempts to tax property, and we have actually, and I'm going to mention, we have 2 red alerts going on that currently. We were able to successfully beat back a bill which would have proposed up to a 25% capital gains tax, basically, on all property, except for very limited circumstances of single family, of your owner occupied home. We were able to stop that. This year has actually been a good year for stopping taxes, and part of it is to characterize a lot of things as taxes. The state, as you know, enjoys approximately, it keeps going up. I think it's right now $97 billion surplus. And so taxes are not on anybody's, and given the inflationary situation, all members of both parties, well, Republicans have traditionally been anti-tax, but we're also seeing that heavily on the Democratic side. There's definitely a very a resistance to new taxes. One way to illustrate that, in our opinion, is for those of you, just to give you a little taste of the process, the committee chairs, the bills go through committees, then they go to if they make it through a committee, then they go to the Assembly or Senate floor. The committee chairs have a lot of influence. They can actually just simply say, no, we're not hearing this bill in our committee. That's it. And that's done. That's the end of the bill. That goes dead. Jackie Irwin, I'm not sure if any of you are familiar. She's a very moderate Democrat from the Ventura County area, was made chair of tax this year. In my view, that meant that there was going to be a more skeptical eye on these sort of tax issues that were going to come out of the Assembly. So wouldn't necessarily stop them by any means, but would definitely not stilt them on one way or the other. Those bills would get a very fair hearing in those committees. So again, good results on the legislative arena, and that has given us a little time and ability. We're currently in, I'm going to call it Red Alert Light on 2 bills, SB 1105 and SB 679. I think Christine is on here. Your dads could probably fill you in with more detail. We're also sharing social media for member mobilization on these. What are these? These are in the city of San Francisco, and I think one other city. They have it's basically an agency, a county level agency, tasked with creating more housing. Okay, well, you know, that sounds good. We're not opposed to that. However, this unelected board is given wide-ranging powers to raise taxes, including taxes on property. So we are very opposed to that. Historically, this is also a good illustration of our own internal process. Historically, the California Association of Realtors has not weighed in on regional matters. This affects LA County, this affects San Diego County. So we would not have weighed in due to local government committee. Now we will weigh in on what are called district bills if the board of directors decides, you know what, it may be just a district bill, but this has statewide importance. So we are weighing in on these. We're not opposed to the concept of these agencies. It's just the manner of their taxing authority and the types of taxes they can raise. So that is our objection, and we are urging no votes on those two. So keep those in mind. Those are two bills that right now we are actively working. It's possible you will also see some other activity in the rental arena. Those are more in the weeds of nuances concerning energy audits and other things which are problematic. But we are still working on those as well. So challenges are there, but it has been a very good year. We've also, as you all know, we've been pushing a home ownership agenda. One of the things, and I stress to all of you on the importance of just in your lives, in your politics, and just everybody to push the value and importance of home ownership. That is under attack, I guess I want to say. Everybody sort of supports this. Home ownership is a good idea, but because of the cost on the coast in particular, you now have a lot of people who do not see home ownership as viable in their future. This is why CAR pushes a supply agenda. The more people see as I'm never going to own a home, then all these things that are important about home ownership sort of start to get more political pressure. So housing supply, which is something we strongly favor, there's a lot of groups that go, well, you know what, this housing costs are so high, we just need to build a lot more rental housing. We even had a proposal this year to basically bring back quote unquote social housing. So we're getting all these things saying, listen, home ownership, one of the biggest things we've been able to push back, and it's a very persuasive argument, is, listen, there's been historical discrimination in this state, in this country, which has precluded home ownership opportunities to people. So what you're saying, if you're saying, oh, well, you know, home ownership maybe isn't the way to go, is to say, so everybody else who's benefited amazingly from home ownership, and this huge benefit to the middle and upper middle class and developing wealth for regular people in this society, is now going to be stripped away from people who weren't able to accomplish that before. And that gets resonance, right? Politically, that makes everybody uncomfortable because it's like, oh, because it's true, right? All of a sudden, those intergenerational opportunities, those opportunities for people to build their way into a better future is being stripped away, which is why I think we were actually successful within the budget, which is the first time in quite a while the CAR has worked actively within the budget itself to try to get some more money allocated toward home ownership. And in particular, the Senate Pro Tem, who our association and our members have a very good relationship in San Diego with, proposed, and we were able to get the California Dream for All program. The regulations on this are still going to are pending, so the exact nuances are going to be forthcoming, but it'll start with $500 million. It's kind of a shared equity program. So it provides a down payment of up to, I believe, 17%. Again, it's going to be worked out where the state would take basically that 17%. It's almost just like a second. And the hope is that people will refinance out of those so that this program will kind of keep perpetuating. But that was a big win to get down payment assistance. And many of our arguments were a big part of that, which is, listen, you have to provide in a society where you are getting these divisions based on income and wealth. This is the way that you remedy those. So a good year, but it's going to continue every year. It's going to be the same. Everybody's like, hey, you're doing, everything's going so well. It's like, you don't know the efforts that go into that. It's a lot. And again, we expect to all repeat next year. I know this is all cliche, but our strength is you. That's one reason we are able to do all these things is you make the calls, you post the media, you go on social media, you're active on your local areas. That's what it is. People come to us for a reason. And I'll give you a quick example. We moved to a support position on a housing bill from Assemblymember Wicks, and you could tell there were all sorts of groups that wanted us to get involved and in various ways, and our voice matters, not just because we're the California Association of Realtors, we have this historic, but it's because of the 200,000 members, right? That's the one thing which differentiates us, especially from any business group. You know, you don't get, sad to say, you don't get the tellers of Wells Fargo getting all worked up for the banks. It just doesn't work that way. So that's where we are. So I have generally good news this year, but we are on red alert on those two bills, and I strongly encourage you to get involved on that. Contact your members. Thanks.
Okay, Sanjay, before you mute yourself, question came in. Could you give those bill numbers of those two Senate bills that you gave? You kind of went through them a little fast, and I don't think people
Sure.
had their pen. So those two Senate bills were what?
SB 1105 and SB 679.
So 679 and 1105. Thank
Yeah,
you.
and SB, hold on, let me just confirm. Yeah, SB 1105 is the one for San Diego County. SB 679 is Los Angeles County. And I'll just be blunt, the LA County one is going to be a little harder to push back on and to potentially defeat. Part of the reason is it's not as expansive as the San Diego one. So the San Diego one is giving politicians in San Diego concern. Some of them are starting to think, I don't know about this. In LA, a lot of the LA delegation is like, well, this is okay. We can, this is okay. We support this because it's a little more limited, even though we still object to it for the same reasons, is this ability to put taxes on housing. And just to be clear, CAR, we do not take positions. We're focused, and one of the reasons we're powerful in what we do is we focus on our areas, right? On real estate, connections to housing. Our problem with this is you're taxing housing for housing, right? If the argument is that housing is a social good, which it is, you need more housing at all levels. We're not just saying we need homeownership. We understand you need affordable housing, you need all kinds of housing. Well, then that's a general good, right? We've got a huge surplus in the state. There's other ways to accomplish that, but you don't tax housing, make it more expensive to get into housing to pay for other housing. That's ridiculous. And that's our biggest problem with these two bills.
Okay, great. Thank you, Sanjay. Before we get over to John, just a little announcement to everybody. We seem to be having a little bit of problems with the chat. If you've got a question, you can put it in the chat. If you can't get into the chat, put it into the Q&A, the questionnaire, question and answer. I am monitoring both of them, so shoot them to either one and we will get your question answered.
Actually,
Okay.
I'm so sorry. Before we go to John, sorry to interrupt. I just wanted to touch based on what other Ed had said regarding buyer broker. I just wanted to give a quick status update on that. CAR's policy committees will be looking at buyer broker agreement at the spring meetings about where we are going to move, whether we are going to go ahead and support asking the policy team to move forward to pursue a buyer broker agreement in California. Due to the importance of this, if we do decide to move forward, we would likely then come back to the board with what we are able to get in the legislature and see if the board is comfortable with what we're able to get. Thanks.
Okay, thank you. John, take it away.
Well, that would certainly be good news, Sanjay, for some of us. I know Ed and I have talked about that. The Tennessee Ed, not the California Ed. That it would be nice to see mandatory buyer broker, and I'll tell you why in a second. So I'm going to throw an awful lot of stuff at you. And then, of course, if questions come up, all three of us can answer them. But I wanted to go over the stuff that's been coming in either to myself or to Lori, your professional standards manager, and then just go over a couple of quick things. Getting a lot of calls lately, and I don't understand why. And Ed Estes and I talked about this a little bit before. The transfer disclosure statement is not a contingency. It is a statutorily mandated document if the transaction falls within those covered transactions. It cannot be waived. If it is sent out incomplete, then it is potentially still allows the buyer to rescind within the 3 to 5 days. Let me give you an example of that. We got a call not too long ago, a couple of days ago, actually, from one of my brokers. They were representing the buyer, the seller, the buyer. They were representing the buyer, and they got a TDS from the seller, And in the section where the agent was supposed to fill out their portion, it said avid form to follow. Well, that's not a complete TDS, and therefore it was my opinion. I don't know if the others agree, but it was my opinion that the buyer still retained the rights to rescind because they had not yet been served with a quote completed TDS. And the support for that comes from some cases that are being litigated and being heard in LA County. Secondly, been a lot of deposit disputes, and I suspect as the market adjusts itself, we're probably going to see more buyers wanting to cancel. We're probably going to see more disputes over the issue. For your perspective, a couple of things real quick. Number one, don't give legal advice. Don't tell somebody that, in my opinion, you're going to get the deposit back. There's a case that the two Eds and I heard about at CAR when we went to our legal meeting, where an agent gave that kind of advice, and it ended up costing them dearly. In that case, the buyer put down a $70-something thousand deposit, which was roughly 3% of the purchase price. And a couple of days later, without doing anything relative to the contract itself, decided to cancel because they found a house they liked better. The seller refused to return the deposit. Ultimately, after mediation was not successful, it went to arbitration, and the seller was allowed to keep the deposit along with attorney's fees amounting to about another $40,000. Now, that case may be limited on its own facts, but that's the problem. You don't know that. You're not lawyers. Under Article 13 and under various provisions of DRE regulation, you don't give legal advice, and the issue of whether there's been good faith removal of contingencies, good faith cancellation, is a question of fact, and they are legal questions, and the liquidated damages provision is complicated. It's a legal issue. Next, Lori advised me that she's still getting tons of calls, as are probably all of us, on the issue of agents refusing to cooperate with each other. And in light of Ed Zorn's comments on the attack on organized real estate, that's really a foolish thing, in my personal view, for you guys to be doing, because you need to be building up the image of organized real estate. And by not cooperating with each other, and I'm saying many of the people here today are doing that, but just generally speaking, the public needs to see a different side of organized real estate in light of all the attacks. Because right now, and Ed's been sending me a lot of stuff to read on the things he talked about, it seems like a one-sided argument. I agree with Ed that the NAR reply recently really laid out some good points, but that's the first time I've seen that. All the other stuff has pretty much been an attack on organized real estate. So not cooperating with each other, which is really for the benefit of the client, which means it's your fiduciary duty to cooperate with other agents, is a huge mistake. I suspect, and Lori and I were talking about this, that we're probably going to see more arbitration claims as the market changes a little bit. We have less transactions. There's going to be more fighting over the carcass. And so we'll probably start seeing more arguments over who's entitled to the commission. And so just be aware, protect yourself, get written agreements, and make sure that you document your files carefully as it relates to working with these buyers. I know that I think all of us, at least the two Eds and I, agree that getting a buyer broker representation agreement makes a whole lot of sense to protect yourself if that's possible. The Department of Real Estate recently issued some warnings on dual agency. One of the things that they pointed out is if you have a long-standing relationship, probably with the seller, because and they gave you their listing, and now you're going to represent the buyer. In the view of the DRE, that's potentially a conflict of interest, and you might want to think twice about being a dual agent. They also talked in this particular article about the impetus to conceal, to make sure the deal went forward because you're getting both ends of the commission, and the fact that it's very, very difficult to be a fiduciary to both the buyer and the seller, particularly in a transaction, the size of the transactions that you're dealing with. In the RPA, particularly today with the market changing on a regular basis in terms of interest, make sure, and I know Ed Estes teaches this class, but make sure that you fill in the interest section of the grid, because again, people aren't doing that. I see it all the time. I don't know if Ed Zorn, if you see it that way, but I just see it all the time. And now you've opened yourself up to a claim that, well, wait a minute. Yeah, you could get a loan for an interest rate far beyond what your buyer is willing to pay. So you should take it. You didn't put a cap on it. So make sure you talk to your client. And again, I'm willing to answer questions on that, of course, but make sure you fill that in and make sure you're very careful about the appraisal section. There's a section now in the grid where you're allowed to put in a number that your buyer may be willing to pay that is below the appraised value. But you got to be careful about that, because you want to make sure you limit that in case there's a counteroffer. I've been told, and I believe that they're going to clean that section up when they reissued the RPA in December. I'll talk about that in just a second. Be careful about issues with possession. Remember, because title transfers on one day, whenever you buy real estate, you're really buying two things. You're buying title and possession. Possession is another issue entirely. And I've had a lot of calls lately where sellers either weren't willing to leave on time or didn't leave on time or left stuff behind where the moving companies couldn't get in because furniture, other stuff was still in the house. So make sure you logistically talk to the other agent about that. And then I recently attended a meeting where Sanjay's boss, the president of CAR, spoke to one of the retreats that I attended. And he made the comment that they've seen an incredible uptick statistically in buyer remorse, something like 40% of closings. There have been indications that the buyers have expressed remorse. And whenever I see the word remorse, I think of I'm mad and I want to sue somebody. So even if that number is true 50% of the time, in other words, only 20% of buyers have remorse, that's 1 of every 5 transactions. And that's a lot of potential litigation. And coming out of the market, we've been in where there's been so many contingent offers of compensation and not so many non-contingent offers of compensation and so forth. I think we're going to see some claims. In terms of forms, I'm almost certain, I say almost because I don't control it, but I've seen and am aware that CAR is going to be consolidating its 3 buyer representation forms into one. This has nothing to do with what Sanjay was talking about in terms of legislation. This is simply taking the 3 present forms and consolidating them into one. And there will be sections for you to then check off whether you're going to make it exclusive, whether you're going to make it limited to a single property, or how you're going to do it. And I know Ed Zorn and I believe Ed Estes agree with what I'm about to say. I have long felt that not putting buyer representation agreements in writing is a huge mistake, both from an ethical standpoint, because Article 9 says everything should be in writing, and also from a practical standpoint. Why wouldn't you take the most likely plaintiff in a lawsuit and have a contract that specifically lays out what it is you're going to do and not going to do for them? So that's good news. So sometime after October, Laura will decide how that's going to get trained. We'll make sure that everybody's aware of these new forms. And the other thing that's going to probably be happening in December is the Forms Committee is taking a look at all the comments that have been coming in on the RPA that was issued last December. I know Ed Estes has been teaching a bunch of classes. I saw his PowerPoint, it's outstanding. I've been teaching a bunch of classes myself, and I think the form is a good form, but there's still some issues. You know, it just came out. The market is dictating some things that might need to be changed. And so they're taking all those comments. So if you have a comment, check with either Laura or I, and we'll make sure to let you know how to get your comments into CAR. And they're having series of meetings at the Standard Forms Committee level, and probably in October, I suspect that they'll make final decisions, and then we'll have a revised RPA for the December form. So that's coming up as well. I don't have time to go over all the new forms. I really like a couple of them. Ed mentioned before that he's a commercial broker, and here where I live outside of Nashville, we have a ton of property that's mixed use. It's residential up above, commercial down below, and when those units sell, you have a mixed use. Well, in California, that means do you or do you not have TDS requirements? Do you have other issues that are natural to commercial property? And now we have a form for that. And the other form I really, really like is we've been seeing a lot of forms that are unfamiliar. Zillow had some forms that were unfamiliar to a lot of agents, and so did other people. And the kids at CAR just came out with an advisory in case you're dealing with a form that you're not familiar with because it's not a CAR generated form, and what you should be doing with that. And I really, really like that form. I think they did a bang up job. The other thing I like that they did recently is they answered an age-old question that I know all of us get all the time, which is, should I disclose prior reports that were done on this property? And you know, obviously that could lead to a lot of questions, particularly if there was a failed transaction, or if I got reports when I bought the property and I don't know whether those issues have been fixed or not. The answer now in the SPQ is basically there's no time limit. If you have a report relative to the property on any issue, or you've made a repair, there's no time limit. And that is now clearly stated in the seller property questionnaire. So again, a word to the wise about that. Fair housing, no longer a back burner issue. So be careful about a couple of things. Ed and his people at CRMLS did a really fine job of putting together some phrases you need to be careful of if you're going to do some advertising. I think they did a bang up job. I know that I was on a panel recently with the assistant commissioner of the Department of Real Estate, and he was talking about the fact that advertising in all forms, but particularly as it applies to fair housing, is a constant source of violations that they see at the Department of Real Estate. So be very careful. As most of you know, hopefully all of you, there is now a hate speech restriction in the Code of Ethics, Article 10, Standard of Practice 10.5. I talked to Lori and I talked to a couple of other professional standards people, and we haven't seen too many of these claims. Where we're seeing them, interestingly enough, is not in the things everybody was concerned about, you know, the political speech and the religious speech. Basically, I'm having a conversation with another agent. The conversation turns to a disagreement. That disagreement then gets heated, and at some point, I say something incredibly stupid about that person's race, sexual orientation, or something like that. That is where I've seen these cases come up so far. That doesn't mean that you won't have an interesting issue come up that could get you in a lot of trouble. And just remember that when it comes to hate speech, they did not limit it to your real estate practice. It is limited to your life. And so if you engage in hate speech unrelated to real estate and social media or somewhere else, could get you in a lot of trouble. I also attended and then was on a panel with a fellow who specializes in Americans with disability. 2-to-1 in California, disability claims are 2-to-1 over race claims when it comes to fair housing violations. So be very cautious about things related to disability. One of the questions that came up recently, got a phone call. You know, somebody wants to know if my brochures are going to be in Braille. Another person wants to know, because they're going to come to my open house, do I need to put in a ramp? Well, first of all, the answer is probably not, because you have to make reasonable accommodations, but be careful how you respond to those things, because they could get you into some trouble, not just because they're legitimate concerns, but there are people out there that are looking for ways to get you. And one of the areas where they're really prevalent right now is in the area of your websites. So again, I don't have time to go into any great detail. And as Mr. Zorn knows, I'm not qualified to talk about your website anyway. Laura knows that as well, because I'm not very technical. But the fact is there are ways you can protect yourself. I have a ton of information, and you should be talking to your IT people. It wasn't mentioned, but there's going to be some implied bias training requirements that go into effect. Some of you on January 1st of 2023, some of you a little bit later, because the regulations haven't quite gotten there yet. And I don't know what the classes are going to look like or be required to be, but hopefully they'll be in pretty good shape. I'm not going to go over the cases in too great a detail, except to say we have a case where the buyer was represented by a broker. The person selling the property was an 80-year-old woman. Later on, she changed her mind and decided to cancel the deal. She sued to cancel the deal. The buyer in turn sued for specific performance. She did sue the broker. And the reason the broker was able to get out of the lawsuit was because, number one, he had carefully documented the fact that he wasn't representing the seller. So his duty was not a fiduciary duty. It was a duty to be honest. And the evidence was pretty clear. He was upfront. So be careful if you're representing, and Ed mentioned before, FSBOs and things of that nature. So be very careful if you're not representing both sides and one side is unrepresented. There are forms for that. CAR has put out forms that basically say, I'm not your agent. In fact, they just revised it in June. So be careful about that. There's a case that came down, and the very complicated case, but the court made a specific finding that a verbal agreement to hold an unrecorded deed or trust deed is not enforceable. And so for lots of reasons, in this particular case, it was an attempt to commit fraud on the bank. And so they made that ruling. We've had a recent case where the court warned people, look, if you're gonna pursue rights that you have, you need to make sure that even if the statute of limitations has not run, you may face what lawyers call the defense of latches. This had to do with a lot line dispute, and so be aware of that. And then we've seen an incredible spike in it's not surprising, frankly, when you think about how many people have been shut down and children haven't had access to their parents, and parents have been isolated, and older people have been isolated or have been the contacts have been limited to caregivers, where we've seen an incredible spike, 30-something% in elder abuse claims. So be very careful if you're involved in a transaction where there are seniors. And then I think I'll close with insurance issues where because of you are in California, I suppose you ought to take note that your CRMLS attorney and your association attorney have both left the state and are now in Tennessee. That might give you some cause for concern, but we're concerned about a spike in litigation. And so don't be afraid to mediate, because insurance is going to possibly become an issue because of costs and people leaving the market. So I think, Ed, I'm going to stop there, give everybody a chance to ask their questions. I see you've got quite a few of them, so have at it. And I have other things here, but for right now, that'll be good enough.
Well, that's great, John. I'm sure we're all relieved that Tennessee has some new DNA being brought in. All right, so we've got a great question coming at you first. I'm going to go ahead and paraphrase it because it is a little confusing. So listing agent gets an offer from another office. So we're in single agency. They go into escrow. While they're in escrow, the listing agent tells a buyer, we'll call that buyer number 2, that the deal is shaky. whereupon the listing agent writes an offer for buyer number 2, and they go into escrow after it's accepted. So now we've got 2 agreements to sell the property, and of course, we only have 1 property. Well, the first transaction, buyer number 1, not that shaky, they go ahead and close. And now buyer number 2 is sitting out there hanging, has an accepted offer, they're in contract, but the property's been sold to somebody else and it has closed. So I guess the short answer is someone's going to lose a license. But John, why don't you weigh on this? I'm sure the rest of you are shaking your heads, and some thoughts.
I actually had a trial. I actually went into trial on a case like that some years back. And what the judge did is he said, well, let's look at transaction number 1, because it hadn't closed. There was basically 2 specific performance claims, 2 lis pendens. So he said, well, the first one's first in time. Let's look at that. And when he decided that that case was specifically enforceable, he ordered specific performance damages and attorney's fees. He then looked at the second case and said, but for the fact that the first case was specifically enforceable, this case would have been specifically enforceable. And he ruled in favor of the plaintiff in that case and ordered a fairly substantial amount of damages, attorney's fees, and specifically held that the listing agent was negligent. Fortunately, I wasn't representing the listing agent, but their insurance carrier had to write a really big check. So the bottom line is I see that periodically. Don't do that. The listing agent is probably going to get out there. I'm guessing based on what I heard, of course, I haven't seen all the documents in my full disclaimer, but based on what I heard, that listing agent is going to be writing a pretty big check. And probably, as you mentioned, and I think you're absolutely correct, will probably be talking to an investigator from the Department of Real Estate and may very well be facing an accusation to have their license either suspended or revoked, minimally to have it put on probation. And remember, whenever anything happens at the DRE, if it's not a citation, it goes on your record and it stays on your record, right? And it goes on your record immediately upon execution. So be careful about these issues. That agent should have written a backup offer, not shaky until they're closed. I consider all deals shaky. I don't know if Ed agrees, but deals are shaky nowadays. They're because of financing in a lot of ways. So I had that case. There was not a happy day for the real estate broker because there was a cross complaint that the seller filed against their broker for negligence and indemnity. So bottom line, be very, very cautious about that. Ed, you agree? Or you have other comments to make? Ed Zorn?
Oh, I totally agree, right? You better be writing a big check. If that's an agent of your brokerage firm, you better start firing people really fast and getting them out. And I would hope that somebody actually reported that and maybe had a disciplinary case filed against them under the breach of code of ethics, right? Because how many are there on that? And so, there's lots of things going on there, but certainly from a broker perspective, you have an agent that is that, I mean, there's really no other word for it other than incompetent. It's time to let them go.
Yeah. Well, also greedy, because buyer number 1 was single agency, buyer number 2 was dual agency. So he was double ending the second deal that never happened.
Yeah, that's not going to end well for the listing agent. If I were assuming he's not the broker, she's not the broker, the first thing I would be doing if I were the broker would be picking up my telephone and talking to my carrier, because I'd want to get my notice of potential claim on file as quickly as possible so I can start having the deductible worked on, because I'm going to be paying a lot of money toward the deductible. And it's not a smart thing. It should never happen, but it does happen. And it happens more often than you would think, because agents, and I think you mentioned it, you start looking at the dollars and you forget that you and lawyers have one thing in common. We are service providers, and our primary duty is to our respective clients first. We get paid later, but we have a job to do, and that includes discharging our fiduciary responsibilities to our clients. And that's a great point. This guy's a dual agent on the second transaction. He's really toast. Okay. And that's constructive fraud. If I recall my cases, you're the professor, but if I recall correctly, Salahoot and some of these other cases, that's constructive fraud. That could mean punitive damages. Yeah,
Absolutely.
not a happy day for that broker.
And self-dealing. Interesting comment coming in now regarding the delivery of disclosures, including the AS, which most of us refer to as the FERPTA form, the importance of getting that into escrow in a timely fashion. Again, seller's supposed to make all disclosures, including FERPTA, I believe within 7 days. Any speaking to that, and maybe while you speak to that as well, the importance of getting that PRBS done. I have seen that PRBS, possible representation, more than one buyer and seller, done in escrow. And the whole idea of that PRBS form is to be done when you take the listing or before you start showing the buyer property, because it specifically deals with the representation of two parties looking for the same property, or two parties having the same property to sell, or the possibility of going into dual agency and having the parties agree up front that if you have to go into dual agency, you will. But these forms are done in escrow because, of course, if they're not done, they're not going to get paid because the transaction file is not complete. But of course, it's not giving the agents any protection that CIR designed. So maybe just throw it out to all of you, the importance of getting these forms in on time. John, Ed, Sanjay?
I think you just answered the question. I'm constantly, I'm not a broker, Ed is. And so he sees it from all three ends. He sees it from the MLS, from the brokerage community, and also as a lawyer who did broker work before he became CRMLS. But I only see it in one way. And I am constantly amazed that particularly listing agents who have had the listing for some period of time aren't prepared. There's so much you can do ahead of time to have everything ready. And these things are going to be due within 7 days after acceptance anyway, and you're artificially creating problems, which is good for me, certainly, because I've got trips to pay for and things like that. But the reality is it's really, really dumb. Not only does it mean you're rushing to get things done on time, which obviously exposes you to potential problems, but also you create problems for yourself. Why? I mean, if you can put, and I know Ed and I have had this conversation, if you get stuff right now, there's going to be stuff, things come up. You guys are basically running through the field with bullets flying past your head half the time. I understand that, but you can avoid a lot of that stress simply by having things ready to go that you got to do. I don't know, Ed, do you agree with that? And Sanjay?
Yeah, I definitely support that concept of, those forms are there to protect the consumer. And I think one of the things, again, maybe just because at the MLS end, we're inundated right now with claims coming from consumers. And the argument is that our industry is very good at doing bunches of meetings and committees and get-togethers and writing forms for us, right, that are fantastic for us. But where does the consumer come in? Right. And so this is a good example of a form that was created to help a consumer, right? Give them the proper notice, give them the proper information. So as they start to go through this transaction that they're unfamiliar with, they don't know about, these concepts of agency, especially in California, are confusing. And you need to get these forms done early. Another one that I always see get tripped up, because we have this as part of our rules when it comes to, when are you doing public advertising? And that is the agency disclosure form, right? Again, guys, that's supposed to be done at the earliest opportunity possible, right? Not you've been working with a buyer for 4 months and now you're going to put an offer in, and now for the first time you're providing an agency disclosure, right? After you've looked at 22 properties. Clearly there was plenty of time to have that agency disclosure done, much farther. And to go to the point of even a buyer representation agreement, I'm still not exactly sure under Article 9 why you should be allowed to get into somebody's home that you don't know, and you don't have a contract with the person you're taking into that house, right? Under Article 9 for a buyer representation agreement. So there's a lot of issues here. I'd be curious, Sanjay, if there's any appetite or consideration as we talk about this dual agency issue. of updating, or how do I say this, bringing more into the modern world, the agency concepts that California has, meaning, we have dual agency at this broker level versus where other states have this thing called a designated agent, right? Where within the agency, I can designate one agent to represent the buyer, a separate agent to represent the seller. And as a result, that's not considered dual agency, and that drives a lot of things with regard to forms and other elements. Is there any kind of thought in the California process of updating that to more the way we work in real life?
Let me, and John and Ed, everybody, and everybody in the crowd will enjoy this. So you're saying reduce liability?
Just saying.
Oh, no.
It'd be a dream.
The trial lawyers are gonna let that happen.
So it's a trial
Let me
lawyer
tell you a
problem,
story.
right?
This is, I hate to do these kind of war stories, but when we were working on updating, a lot of the terms in the real estate law to kind of better reflect the, this old concept of selling broker, and we changed that to buyer's broker, within the law, like we were updating all kinds of things. And as John mentioned, yeah, the consumer attorneys are very opposed to that kind of change.
Okay.
But what's interesting is they had hired an expert who is actually, the name's escaping me right now, but was one of the top real estate professors. And he sort of just said, hey, I'm speaking for myself, not for anybody who's retaining me. Hey, this designated agency thing might be a good way to deal with these problems in California. But yeah, in the short run, there's not much appetite for some of that.
Okay. That's kind of what I assumed.
I asked my counterpart at NAR, because if you look at Article 9, it is very clear, and I know everybody's read it quite a few times. It says that a realtor shall be responsible for putting all agreements in writing and provide a copy to the parties as soon as practical, right? That's what it says. And then it says, including but not limited to, and it says listing agreements, and then in further down amongst all the documents, it says representation agreements. So I simply said, why does California, in my rather Pollyannic approach to things, I said, why doesn't California enforce that? Very simple, because California doesn't do it that way, and so we kind of don't really push it in California. But I suspect that we're going to see something pretty soon. Either a lawyer's going to be smart enough to sue a defendant and put up on the silver screen in front of the jury in his opening remark, Article 9 of the Code of Ethics, and try and establish initially this broker had the ability to put something in writing, and this broker didn't do that in violation of their Code of Ethics. I don't know why that hasn't been done. Maybe it has. I've been put out to pasture, so I don't litigate anymore, but that's certainly an issue. I personally, and again, I know Ed's done a lot more stuff here in Tennessee than I have, but I've done a couple of deals, not as a broker, I'm just a simple consumer. And I've never been able to work with a realtor that didn't require me to sign a buyer broker agreement before they got started. In fact, that's what the letter said. We will get started when we get this form back. And you know what? I'm good with that as a consumer. Why? Because now I have something in writing that tells me what Ed's going to do for me and what he's not going to do for me. Doesn't that make sense? And if you made it mandatory or in some fashion really pushed it hard at the CAR or at the legislative level, then isn't that good for the consumer? Right? Why do you do a listing agreement in writing? For the same reason. You have to have a written agreement in order to earn a commission. Why? Because the statute of frauds says those kinds of things are prone to being misrepresented. Well, in a misrepresentation situation, who loses? The consumer or the fiduciary? And so I would think that the fiduciary, particularly when it comes to the buyer, who statistically is the most likely plaintiff in a lawsuit post-close, I would think you'd want to have a buyer broker representation agreement. And I applaud CAR for coming up with the idea of consolidating those three forms. I never really have understood why there's three. you and I, Ed Estes, disagree a little bit. I know we've had offline conversations on the exclusive nature. I don't have a problem with limiting it the way you were talking before we got started, but I really just like the idea of it being in writing. And I will tell you, having sat in on dozens of procuring cause cases, if somebody can produce a buyer broker representation agreement and an agency disclosure, which I agree with what Ed Zorn said, should be done way sooner than most agents do it. That's considered strong evidence of procuring costs. And if you want to win your commission dispute, those things are going to be very helpful to you down the road.
Yeah, the question I have and the concern I have is, okay, then for consistency's sake, if you're going to take the 3 buyer representation agreements that CAR now has and move them into one with the check boxes, then let's take the open, exclusive agency and exclusive right to sell, move them into one with boxes. That's going to get confusing. So I'm not sure CAR should go down that path, but that's a different discussion. Real quick, Sanjay, would you put your email address into the chat? We have some people who want to contact you or reach out to you on some legislative issues, and that might solve that. Second, we got a question coming in from Marianne. Any information on possible cap on capital gains on the sale of homes? So Sanjay, I think you deal primarily in California, and then of course we've got federal taxation, but is there anything out there about possibly changing? I'm assuming it's the $250,000, $500,000 exclusion for 2 of the last 5 years of occupancy.
Right, it would have to start federally, and there's no, and just as a FYI, there's no guarantee that California would follow suit if the feds lifted the capital gains exclusion. But there is some traction on this issue. Here's some of the political complications. Of course, this primarily affects blue states, right? Primarily New York, California. However, just like with SALT, we're starting to see some of the red states finally facing this too. Texas is a good example. I know they have no state income tax, but SALT, they have very high property taxes. So as their prices start to balloon, they're now falling into SALT. They're also seeing those kind of gains, which are the kind of gains which the capital gains exclusion now makes them realize, like, oh, maybe that's not sufficient. We are getting some, meaning when I say we, I mean NAR, is getting some traction with discussions to at least starting the possibility of indexing it, because it hasn't been indexed for inflation since what, 86, I think, the tax reform, 85. So at least maybe to start the indexing, because there is a recognition that there is a bit of a problem here, that there's been no change in that period of time. So it is getting some discussion, it is getting some traction. There's all these political issues though, in terms of where these happen to fall. It's really New York, California, parts of Florida, but as you get more of these states seeing these higher prices, maybe we can get more traction.
Okay, got another question coming in, and maybe we'll bifurcate this because we've got the duty of cooperation in the NAR Code of Ethics that falls into it. But the question is, does the buyer's agent have a duty? Maybe let's first talk about legal duty, then we can talk about an ethical duty, but a duty to remind the listing agent that the TDS is incomplete. And maybe we could just extend that to, any document being incomplete. I don't know if we want to go so far as to go to the AVID. If you get an AVID from the other agent and they didn't fill it out, do you have a duty to remind them in terms of protecting your client? John, Ed, you want to jump into that first?
Go ahead, Ed. You said your mouth was open before mine, so go ahead.
Yeah, this is where it's tough, right? Because I have a fiduciary duty to my client, the buyer in this situation, right? And one of the things, if the listing agent isn't that good and doesn't properly complete the TDS, I guess I'd have to know what level it is. Right? If it's a kind of piece of information that is critical for my buyer to know, then I would remind them. If it's some other technical thing that is a piece of fact that I can develop or understand or know already, right? Do I really want to trigger the timeframes? Right? I mean, it's a balancing act, right? Of I have a duty to cooperate with the other agent, but does that duty go above the fiduciary duty that, hey, if I can squeeze an extra 4 or 5 days out of this, contingency for my client. Now, if my client, I might go to my buyer, honestly, what I would do and say, hey, look, they're missing this piece of information. The timeframes here are modified because of that. I'd like to tell the listing agent that I'd like to go back and say, hey, you missed this. Can you get us the piece of information that's missing out of this, please? And that would then, restart that clock as necessary. But I would probably want to consult with my buyer first and bring them in on that, since I'm a fiduciary for them, and explain the situation to them. Probably 9 times out of 10, I'd have my buyer in a place where the timing isn't a problem anyway. So we would probably go ahead and say, yeah, hey, let's let them know we need this piece of information. That's probably how I would handle it, is consult with my buyer first before I go to the listing agent, with the intent of going to the listing agent after I consulted with the buyer.
My first answer would be the same answer that all 4 of us would love to give most of the time. It depends. First thing is I agree with Ed, that first thing you do is talk to your client, because that's where your responsibility lies. I'm not aware of any express duty to go to the other side and say, hey, you messed up, and fix it. I will tell you that just recently, I told you that I got in a TDS, or my client got in a TDS, and it was not complete. It did not have any part of the agent's section filled in as is required in order for a completed document. And so, because it was a non-contingent transaction, we decided that, well, they did a pretty good visual inspection. It really wasn't essential. So let's hold that card to see if there's any reason why we need to cancel, because this person didn't realize that they've given us 3 to 5 days to cancel, regardless of whether there's contingencies. But then I've also seen situations where, going to Ed's point, where the buyer knew that the information wasn't complete or frankly incorrect. And so that raised 2 questions. One, if it's incomplete, do we want it completed? Is it necessary? Goes to Ed's point. But number 2, if it was purposefully not correct, then we put ourselves on red flag alert, because we know, well, A, my client wants this house, but B, we're dealing with people that may not necessarily disclose everything, and we need to be extra careful during our inspections and other portions of the transaction to make sure we're protected. It's a complicated case, but again, what we see in the real world all the time, according to your professional standards manager, is lack of cooperation. People don't do that kind of stuff. And again, the first order of business, is it good for your client? Is it something you need from the seller side or somebody to complete? So.
Okay, this last question now in the chat. So I just want to remind our audience, if you have any questions, now's a good time to put them in. Put them in the chat if you can. It's the easiest for me to access. If you can't access the chat, you can use the Q&A. John, Ed, this is in regards to the ordering of a preliminary title report upfront or in advance. And just to kind of lay some groundwork, there is a RESPA issue of agents ordering a PR in advance because they have a relationship with that particular title rep or that particular title company, and they're trying to give them business. So if they order the PR up front, then that's a persuasive tool to anybody making an offer that this is going to be the title company that we're going to be using, even though that's something to be negotiated between buyer and seller. However, on the flip side of that, and I have one of these right now, if you're dealing with, let's say, a testamentary trust, and maybe not everything has been done, and we're still trying to verify the authority of the trustees, the pre-order of a title policy could be a good thing because it gives the title company a running head start. The issue of ordering reports, documents up front, concerns that either of you have on that?
So I would argue that if I'm a listing agent, especially if I have a challenged seller, right? Like you're saying, some kind of death, some kind of, you get wind of the quit claim deed somewhere in the history of me having that, kitchen table conversation. I don't see any problem, again, in consultation with the seller themselves, saying, hey, based on our conversation here, it's my recommendation that we get a preliminary title report done, and let them be aware, right? Because again, when an offer comes in, who's going to pay for what is a separate conversation we'll have later, right? But I could see some certain benefits. We've all had those transactions, right? Who hasn't had a transaction where's the mystery lien, right? That the seller had no idea that this lien was sitting out there. And it might take, 30 days, 45 days, 60 days to get that issues and the paperwork moved around to get that resolved, right? So especially in a hot market, seller's market, things are flying off, transactions happen quick with short escrow periods. I don't see a problem, again, as long as it's properly disclosed and my seller is saying, yeah, let's spend the money to get the preliminary title report. So I get that commitment from them that they're comfortable paying for it. And then if we push that cost off later on somebody else, well, hey, then maybe we could do that.
Yeah, that's the way you post. By the way, you guys remember the word cold? I have a cold. I was tested yesterday. I'm good. So I just have this cough, but there's this thing called a cold that I apparently have. So I apologize. Couple of things. You mentioned getting paid under the I just finished a case where my client was being accused by the Department of Insurance in a situation where the title rep was going around offering goodies in order to drum up business and push business. You got to really be careful about that because that is a separate issue. The RESP issue is really, really an important issue. If you're getting money from any source whatsoever, A, you have a duty to disclose it under the Code of Ethics, but B, if it's otherwise in violation of the law, you got a problem. As far as ordering up a preliminary title report early in the game, I think that's smart. I know that there's some of the people that, Marion and Linda and a couple of other people that I know are online here that do that early in the game to see what you got, right? I don't think that's a problem at all. I'm working on a transaction right now with a client and it's my case from hell. It's why I know I'm going to go to heaven for sure. And in this case, the title is so messed up, is so bad that knowing it now before he starts marketing the property, and it's a piece of vacant land, it's not residential, but knowing what the problems are so I can sit down with the attorney for the title company so we can figure out how we can get through this is critically important in terms of, working with a residential seller. Yeah, I think it's a good idea up front, as long as you're not being, compensated and as long as you're not breaching your fiduciary duty. I will tell you, just as an aside, not really necessarily related to this question, I was talking to the DRE head of legal affairs recently, and they're taking the position now, and they put it in writing that if you recommend a vendor, even though it says in the contract, you're not liable. If you say, for example, recommend a contractor, you have a duty, if you recommend them for a contracting service, to confirm or at least mention that you have not confirmed that their license is in good standing. So that's something I hadn't thought about before. We haven't seen too much of that, but I have a case right now where that is an issue. So just be careful about that kind of stuff. I don't think it's a bad idea to get a preliminary title report for the reasons Ed stated, but if you're getting paid and you're steering any service, escrow, you better disclose fully in writing what the circumstances are.
John, we don't have any questions in the chat right now, but you did mention that the CAR Standard Forms Committee is looking at making some changes to the RPA. Now, we know that not CAR's fault, but the legislature brought in that appraisal disclosure literally at the last minute. It's kind of like kids running through the kitchen right after someone mops the floor, right? And they had to do the addendum because July 1st, the statute came into effect. That is being talked about being included, which means we'll go from 16 pages to 17 pages. That's a question. I don't know. What else do you see? What's your crystal ball telling us, even though that crystal ball might be a little foggy? that we might see in terms of a revision come November?
Well, I think that they're gonna clarify a little bit that appraisal section, because there have been a lot of questions coming up about that.
Now, this is in paragraph 3 about
It's
the
on the
minimum
grid.
amount.
Yeah, right, right.
Okay, because that problem with the purchase agreement is when you say that section, well, it's actually 2 sections because
true,
it's
true.
first 3 pages, last 13 pages. So thank you.
So I don't know, as we sit here today, right now, the addendum, the fair housing appraisal addendum, or the fair appraisal addendum, I think is what it's called, which is just a 1-page document, is bundled. They added it in June. I think that was really one of the only changes they made to the RPA, and now it's bundled. Whether they leave it that way or they make it a standalone addendum, I'm not sure what they're going to do. I personally don't, it's not a big problem because all you're doing really is handing out an addendum. As far as other things are concerned, they issued that delivery of the delivery of notices. They may include some language in it to where they might sunset that. They're just, when I talk to brokers, and Ed, is a broker, and you talk to the same people, there's still just a lot of questions about, some of the language. And I had a call recently, there was an ambiguity about possession, right? It says you got to give a notice in 5 days. But what if they didn't remove that? But that really applies to debris and to cleanup. But what if they leave all their furniture behind because they just didn't get it all moved out on time? And now the moving vans can't move in the new stuff. And now the buyer is being damaged because their furniture has to be stored until the buyer moves out. Does that give the seller an automatic 5 extra days or not? Those kinds of things probably get cleaned up.
Okay. A question just came in about putting the termite inspection, well, I don't think it's the inspection, the termite work, section 1, as we know, back into the purchase agreement. So maybe whoever wants to jump on this question first, Fred, or John or Ed, 2 issues. Currently in the purchase agreement, under inspections, you can ask the seller to pay for a termite inspection, which we know is a structural wood pest destroying organism inspection, but you can ask them to pay for the inspection. The thing you should not be asking for is to have the seller do the work, because the seller doesn't know what that work is going to cost. Anything about addressing termite in the purchase agreement, and maybe also provide your opinions as to why we don't have the ability, and it is discouraged, to ask the seller to pay for termite repair work. John or Ed, take it.
I remember when they were sunsetting the old separate form, that there was much wailing and gnashing of teeth because it was no longer going to be a form out there. And frankly, the way they've set it up, it's all inclusive in the contract now. I don't have a problem with it. And I suspect, and again, I'm not a CAR attorney. There's some of the finest lawyers I know. I'm pretty much sure that once they sunset it, they had some pretty good reasons and it ain't coming back. The other reason that they sunsetted it was because I'm agreeing to pay for some form of inspection. It's in the counter offer, and it's in that addendum that they used to have, and nobody bothered to put a cap on it, right? Sure, I'll pay for phase 1, or sure, I'll pay for phase 2, or for both. And I remember there was that case out of Northern California where the termite report came back and the damages were like $101,000 or some outrageous number. And hard to get happy when you get hit with a bill like that. And the seller was not pleased because they'd never been told, maybe you should cap it, or maybe just cap all repairs. We're not willing to pay more than X number of dollars. In this most recent market, sellers haven't had to do much of anything, but as the market starts to turn and become a little more buyer friendly, maybe we'll start seeing some of those. But no, I don't suspect that we'll see that form back again. And B, you ought to make sure, if you're going to agree to do any work up front, that you put caps on it. And get, as I understand it, in the new request for repair, Ed, the Ed Estes, that the new request for repair does have something in it that says, and you will remove your contingency if I agree to this. So I think that's pretty good stuff.
And I just wanted to chime in, John. I think there are a number of reasons. I was actually on the legal hotline when they first removed that in the purchase agreement. And that was in part, just speaking from my experience on the legal hotline, when you would get that stomach churning call from the agent, which was, well, the practice in our area is the seller pays, so we never, and yeah, 100,000, the seller's like, whoa, what just happened here? I now have to pay 40,000. Like, that happened way more than you would think. And yes, if you trained everybody, that should never happen, but it happened a lot.
Yeah, I
And
have,
one
I have
part
a
of it-
All around, right?
I have a $21,000 termite repair bill right now. Everyone's good because nothing was agreed to, but the termite repair came in at 21,000. Ed, I think you have
Yeah,
something.
wasn't there a period of time where Sanjay, where that was some of the state law? Like there was some kind of state law, at least as far as getting the report?
Well, it's interesting. If it's put in, like, part of it is, that's why it's completely out of the contract. Because if
Now,
it's
right.
made part of the contract, it triggers certain obligations of California law. Now that it's not part of it at all, it's
Right.
it's negotiable. It just becomes, and once the negotiation takes place, then the regulations kick in as to the duties of the pest inspector, et cetera. But now that it's just out, it's out.
Question came in,
I
some
just
sellers,
want to say real quick.
I'm sorry, go ahead.
Just real quickly is that one of the things, and Ed and I were on a panel recently with an attorney by the name of Dave Bright. I know most of you know David. He's one of the finest lawyers I've ever met. And he made a comment, slow down. Yeah, again, we could talk about all these different things, but he made the comment, he says, look, people are just in such a hurry. Things are so hectic right now. People are so busy. Slow it down a little bit. Think through some of this stuff, right? You know, the reason somebody gets hit with a $100,000 bill is because they just simply checked off a box or filled in a blank, and nobody thought through the unintended consequences of what you're dealing with. And I know there's a bunch of defense lawyers out there that, you know, will tell you, look, you got to just slow it down and think through some of this stuff, because it's just critically important that you think through what you're agreeing to in advance. You're forming a contract. You're forming a contract probably for, what's the median price in California now? 800,000, something like that, right? So that's a lot of money. Here in Tennessee, that's a whole lot of money, right? So you got to be really, really careful. Just slow it down a little bit. Think through this stuff.
Okay, you guys are going to love this one. It says some sellers, but I would say virtually all sellers, don't know a title or an escrow company. Is there a form or disclosure for the sellers to sign that they agree for the company that we pick for them? I guess sellers are going to assign their rights, or the buyers are going to assign their rights to their agent to just let the agents pick the service providers. So of course the answer is no, but I know we're not going to stop there. John, Ed, go for it.
Well, from a legal perspective, you're right. The answer is no. And the reason that you shouldn't do that is, are you going to indemnify your client against the negligence of the person that you pick? Because they're going to say you picked it. I just think that's not. Now you can make recommendations, and I know that, you know, there's all kinds of different ways of vetting out whoever you're picking. But too often, what I see is it's steering towards somebody that's going to get you a benefit of some sort, either a profit bonus or some kind of, and you just got to be careful about that. But the other reason is, if you do pick somebody, you better be pretty darn sure that they're going to do a good job, because if things go south, you're going to be the one that gets blamed. Ed, Sanjay, your thoughts?
You're honestly, guys, you're going to get stuck anyway. The point of the comment here is the seller's not picking. The seller doesn't know, they're not going to, what are they going to go on Google and look at, spend a half hour on Google looking at escrow and title companies? Where do you pick, like, where does the seller pick the company? You do know it's a drop-down box on the form, right? So the seller doesn't even have access to that form, right? It arrives on their table picked by you, right? So I agree from the legal standpoint, we don't pick, wink, wink. But you better make sure those escrow and title companies are good, because you arguing somewhere 2.5 years from now that you had no involvement in that and the seller really selected that, you probably want to save your breath because you don't look very credible if you're going to make that argument. So some things about doing real estate have a risk to them. You can manage that risk, but it will never be eliminated.
And frankly, one of the values that a realtor brings to the table is you should know who the people are that you are going to be recommending. And I just think one of the overlooked values in risk management is properly vetting the people that you're going to recommend. And whether you come up with your own in-house, I know what the CAR contracts say and all of that, but the bottom line is this, as Ed said, I've never, like I said, I've always been on the receiving end of the broker services, but from a legal end, you're going to get blamed, right? The plaintiff's lawyer is going to look for the needle in the haystack, and if that happens to be the needle, that's what he's going to base his case on. So you need to be careful about who you recommend, and if you end up picking, you need to make it clear why you're picking them, and it better not be for self-interest.
And if you really want to do this, and really protect yourself all the way on that, if you have, as you're going through and putting together your offer for a buyer, as an example, or your listing presentation for a seller, do you have a slide on your PowerPoint deck that talks about, hey, here's 3 or 4 different escrow companies and their associated fees. Would you like to pick one of these? Or would you like me to get you some information so you can be involved in that? Even having a slide like that with choices and options and a conversation could help you in a subsequent, type of an action. So it's definitely something you want to talk and educate. I mean, big job of what we do as brokers and agents is this is an extremely complicated, scary, emotional event our seller and buyer are going to go through. And we're there to kind of hold their hand and give them advice and consult with them on that. Right. So telling them what is an escrow company, what do they do? What is a title company and what do they do? And why do they charge these fees? And what's the benefit to me? That could lead into discussion of, would you, seller, like to, have me get you some information so you can pick the one you would like? Having those kind of conversations are totally legit, but don't think that's going to get you completely out of the liability question.
Okay.
It's
Got a
called
question.
risk management for a reason, Ed.
Yeah.
Right? It's you're managing
It's
your
not
risk.
risky elimination. Right?
Yeah, there's no such thing.
Right.
Okay, got another question coming in, and I'd like to preface this that there is no legal duty for a seller to inspect their property. They are disclosed what they know could affect the value, but they don't have to inspect their property. And of course, now the listing agreement has been modified to allow the seller to order certain inspections up front. Of course, as John mentioned, if you order those inspections up front, then you're following the recommendation of the seller's inspector. Does that
I'm sorry.
prevent or cause the buyer not to do an inspection because they got the seller's inspection? So the question coming in from Marion, is it a good idea to have the seller order a termite report up front? And maybe we could extend this about property inspection, physical inspection, something along that. It's kind of a dual-edged sword, just like your thoughts on that, because we know buyers come in and their agents do write offers saying seller to pay for section
Uh-oh.
1 work or something like that. Ed, John?
So again, the great lawyer response of it depends, right? And here it's not a lawyerly depends, it's a market depends, right? What's happening in the marketplace? What is the property itself, right? Do I have a problem property that clearly has some issues to it? So we're going to disclose those things anyway. So we want to know what that is and complete. Do I have a beautiful property that I don't think there's any issues of? Do I really want to go out there and start hunting and churning up the hay to see if like a needle drops out? Those are, it's probably really dependent upon the property itself as well as the market. I understand a rationale or a reason for it. If you do have this hyper accelerating market, if you're in a market where you're going to tell people there will be no inspection contingency, some of these kind of issues, does that maybe pop in? I would have to say it completely depends on the property. I've done both, right? There have been times where I have a concern as a listing agent, especially if I have a, how do I say, a seller who I feel maybe isn't quite telling me everything that they maybe know, right? That raises a red flag for me. And for me then to continue in my representation of them, I may say, hey, why don't we have a professional come out and take a look at this, and we're going to provide whatever they say to the buyer, right? I would perhaps leave it in that, kind of context, but I would not, I don't do it as a routine.
Okay. Any other comments before we go to the next question? Okay, so there are two I have not read all the CAR forms, but there are two that are just incredibly challenging. Sanjay, not throwing rocks at CAR, but that new COP form, it can be a bear to get through. And of course, let's not forget about fire hardening and defensible space. That form is just somewhat overwhelming. But in regard to the FHDS, fire hardening defensible space, the seller have to order an inspection from the fire department if the property is in a high fire hazard zone. So the good thing about the agents is you don't have to really do anything. You just have to give the form to the seller to fill out if you're in that. Well, you got what, the three, basically, property built before 2010 for home hardening, or for both of them, TDS is required and you're in that high fire zone and your NHD report. So you've determined that you need to give the form to the seller. You give the form to the seller, and the seller says, what the heck am I supposed to do? So Ed, John, what the heck are they supposed to do?
I'm waiting for the first lawsuit to be filed so I can figure it out. I mean, I agree with you, Ed, that those two forms that you mentioned are, you go through that, and I've listened to Gov, I've listened to Neil from CAR, two incredibly fine lawyers. I'm still trying to figure it out. I don't know if you have a better solution, or if Mr. Zorn does, or Sanjay, I'm still trying to sort through it. I read it.
Sanjay, can you fix that? Because isn't part of the problem with that legislatively? Let's just say when the legislature drafts things, it's not the most elegant of prose.
That one is a mess, and
Yeah.
we're looking at, and we've talked to legals about ways to fix it. I'll be frank, that the problem with the whole fire hardening thing is that's the reason it ended up so convoluted, and I will be the first to tell you that yes, that's a very convoluted bill, is that there was so much back and forth to try to stop it, frankly, from being worse transactionally. Because while we're generally good about being able to stop point of sale, the whole fire issue, for obvious reasons, has become very difficult, because in theory, all this bill is, California law already says you should be in compliance. You're supposed to be in compliance, right? Like, as of, that's just always supposed to be the case. But we know that's not the case. And that's what makes it so challenging, is basically this whole thing to try to make it that you get into compliance, but that there's some bargaining involved, because if I recall correctly, you can kind of switch some of that to the buyer, but of course there are risks that if the buyer then is stuck with a big bill to do the defensible space, it could be very problematic. But we have thought about ways about trying to approach the legislature to try to say, listen, this is just way too complex, and we've got to do something about it. So but again, anytime you weigh into fire, you get a lot of competing issues there.
I think if you get an issue with the form and how to comply, is call your lawyer and let them screw it up. Because, frankly, it's a mess.
One thing is to take a look at that. There is some language regarding compliance with local ordinances. So we encourage, and I don't want to throw this on your local, but we encourage GATS to enact local ordinances, because once you get local ordinances in place, so for example, in the Truckee area, their local ordinance says any inspection done within 3 years is a valid inspection, or something like that. So most of them have it done. It's done, and that complies with the law. So a lot of it is to see if you can get local vegetation management ordinances put into place regarding inspections.
And I will say in CR's defense, because it's really not their fault, it's the legislature, I think CAR has a really good kind of a Q&A roadmap checklist.
Yeah.
When you print out that FHDS, then 2 more pages full out. It's kind of a grid on what you're supposed to do, where you can go, and they give you some websites to try to navigate through. But John, you made an excellent comment from, I think, David Bright, slow down. A lot of that FHDS form, you just kind of say, okay, I don't know. And you quit checking boxes, but just give the form to the buyer. I know how hard it is for agents not to check a box, because if there's a box, we need to check it. But in that FHDS, a lot of it, you don't just check a box. And I had a transaction I was helping with where we weren't in the zone, even though there was a fire within a half a mile of the property, a big fire. And we weren't in the zone, so no boxes were checked. And they're saying, well, you got to check, but no, the form says if you're not in a zone, you don't have to fill out the rest of the form. And if you don't have to fill out the form, John, Ed, please agree with me. For God's sake, don't fill it out. Go ahead.
Yes.
Yeah, no,
I completely agree with that. Yeah.
I had a transaction recently where we got in the offer, and is a friend of mine, and she asked me if I would, take a look at it, and every box was checked. What, whether they had wells, or whether they had city water, whether they had septic, or whether they had city services. And immediately I knew that the agent who presented that offer, how do we say it nicely, not up to par, right? Not up to snuff. And so, no, don't fill it out if you don't need to. And if you're not sure if you need to, the other thing besides slow down is don't be afraid. I've been a lawyer for 40 years. Ed, you've been a lawyer for a long time too. Sanjay, you're too young to be a lawyer for a long time. But, the more I know, the more I call other people because I don't know. And the reality is that don't be afraid to say, you know what, I'm not sure what the application is here. Let me check it out for you, and let me get back to you with, correct information, because the goal isn't to play gotcha. That's the trial lawyers, consumer lawyer, whatever they're called now. That's their job. Our job is to try and protect the client the best way we can. And sometimes that means calling in somebody else. Okay, nothing wrong with that if that's what you need to do.
All right, someone just wrote me a book, so help me. Let me take my time to get through it. It's quite long. They have a listing. They received 3 offers. One was not the higher, but it was with 20%. I assume that's down, and the buyer was willing to remove contingencies within 10 days and close within 15. And then, so wasn't the highest offer, but it had more attractive terms. Then on day 10, the buyer sent the seller a request for repairs, even to do what was agreed, no repairs were to be done by the seller. So they basically said a non-contingent or low contingency offer with no repairs. Seller accepted because that was the most attractive. And now they're throwing in the request for repairs. The appraiser didn't ask for any repairs at the time the contingency removes were sent. We get a demand to close escrow, but the buyer never responded in writing. Seller wanted to keep the buyer's deposit. Finally agreed to give it back. Buyer, in order to put the property, oh, there's just too much here. I'm just going to have to skip this one. I'm sorry.
Well, can I ask?
We can answer part of it. Yeah.
One part of it that I get.
Yeah.
So basically you have a deal that's gone bad. Okay.
Yes.
Buyer stopped responding. What are you doing? I can tell you from the MLS, right? If your deal's gone bad as the listing agent, you can put it back on the market. You can put it back on the MLS, right? You do not have to wait for complete resolution of what's happening with the deposit before you put it back on the MLS. Do not allow that to hold a property hostage, right? And when you represent a buyer, please don't force a listing agent to hold that, property hostage on the deposit to try to squeeze that back out. What you do is you close, you put it back on the MLS, and you simply put, under agent comments, previous transaction fell through, sale contingent on cancellation of prior escrow. You do that at the compliance department, we're good to go. You get that property back on the market for your seller, and try to find that next buyer with that, that contingency in there of this, conditioned on, getting that other escrow, closed out. But we don't want to let, properties be held hostage as a tactic for a buyer who should be giving away the deposit, to keep the deposit.
Okay. This question kind of
I have a
moved forward
comment.
is, but
Go ahead. I was say, I have a comment too, but before.
okay.
Sanjay has to leave at noon to protect us from crazy legislation. So I want to, as the association attorney, and I know Laura feels the same way. I know how busy you are, Sanjay, and I know,
Thank you.
in my view, government affairs and what you pay toward government affairs, frankly, is the most valuable part of being in organized real estate. And so Sanjay, on behalf of myself, and I know Laura and the board itself, thank you for taking time out of your busy schedule. You're one reason why Zoom meetings are good, because we don't have to fly you down here anymore.
Next year I'm coming to, but anyway.
Um,
Tennessee. All right, thanks.
The author of that earlier question also brought up an issue related to procuring cause, where buyer is looking with property with one agent and then claims to have maybe seen the property online and then maybe working with another agent. Obviously, the buyer representation agreement is probably the most important document to keep buyer loyalty. Any thoughts on the idea of, getting loyalty with buyers, trying to hang on to a buyer if you don't have a buyer representation agreement? Maybe let's just throw that out for random thoughts, John, Ed.
So my concept on this is there's nothing less connecting you to a buyer than this concept of, quote, introducing them to a property that's for sale. Unless you're telling me that property is, has no listing agent involved, right? And you're hunting for them to find a person who's not listed a property yet. Outside of that very limited situation, the fact that you introduced, quote unquote, someone to a property and told them it was for sale is probably the lowest level of relevance to a procuring cause case in 2022.
Because the internet.
Let's be honest. Every listing that's for sale is on at least in CRMLS's consideration. Realize we send our feed out to 25,000 different websites. So that's not the thing. What we're really looking for from a procuring cause perspective is, what did you do next, right? Did you show the property? Did you write an offer? Did you try to get them qualified? Right. These are the kind of steps that talk about procuring cause, not the fact that, you sent an email to someone saying, hey, 1, 2, 3, 4 Main Street's for sale. That really didn't help a consumer in any meaningful sense.
Sitting in on these arbitration cases, typically, and of course, that's why we have 20 different procuring cause guidelines. Typically, unless you've actually written up an offer that's reasonably similar to the offer that was written up, that actually closed, you're going to have a hard road to hoe. I mean, there are ways. There's really two, although all the issues are technically supposed to be equal. When you have a buyer who clearly has been working with somebody else, you better ask what that representation is, because you're buying yourself a lawyer problem. Number two is, if you haven't written up an offer, then look carefully. But if all you did was introduce them to the property, unless you have an exclusive agreement with them, which you probably don't, then you're probably took. The question that you asked before, though, the first thing that came to mind for me while I was listening to Ed was that, did the buyer's agent know while they were writing up the offer that they were really not going to live up to that offer? Because there was no duty to do any repair work. But if I know I'm just tying up the property, so now I can come in with all these other offers or all these other demands, that's actually unethical. And of course, proving it's one thing, but that's actually an unethical practice. So be very, very careful about that. Getting yourself in a lot of trouble. I noticed that you have to leave, Ed. And I
No,
noticed
no, Laura had to leave. I'm in
Laura
charge.
has to leave.
I'm
Oh,
in charge.
well, now we
I'm
can
now
talk
the
about it.
host.
Okay. But I thought, what time is this supposed to end anyway? I thought it was.
I think it's noon. I don't have any questions in the chat. So if you guys want to just provide your musings for whatever you think would be beneficial to the remaining participants here, I think that would be great. This has been a great presentation, lots of good information, and your respective experiences are truly unparalleled in the industry. So some final comments?
I'll go first since I went last the last time. I just have to say, number one, I think that what's going on with the multiple listing service, and Ed has been great at keeping me up to date of a lot of the issues, certainly not at his level, but I've been reading an awful lot of stuff. My eyes are getting buggy. That you need to pay attention to that, and you need to start thinking about where we're going to be heading with this stuff. That's number one. And then again, we're heading into a market that probably is going to look a little different than this crazy market you guys have been dealing with. And so be prepared to make some changes. Realtors tend to lag sometimes behind, well, we've been doing it this way. Well, yeah, you've been doing it this way because the market was doing it that way. Now you're going to have some different issues. I think the Fed raised rates again yesterday, if I'm not mistaken, and they're going to probably do it again because we hit our second quarter of contraction. So they're looking to do what I don't know. So be very, very cautious. Keep up. Laura does a great job of keeping you guys up. Ed teaches classes. I periodically will teach a class. I usually do some type of a summary thing. This is probably more important than ever that you write checks to when you're asked to the government affairs program, because it is critical to not only local but state and federal. And then two, you got to keep up on what's going on. The MLS being, I think, right now the single most important issue, but there's also lots and lots of other issues. So I guess that's my musing. And slow down. Right? I see more agents get in trouble. And remember, I don't sue agents. I just defend them. I see more and more agents get in trouble simply because they're rushing to get things done. And you can do a lot of the work up front, so that's not necessary. Take a risk management class. That's all I got to say, my friend. Thank you again, Ed. You always do a great job. Both Eds.
Ed, some final comments from you, please.
Sure. Yeah, I would certainly echo the slow down, not only in your transactions, because that's where mistakes are made. And the good news is we're entering a market where you can. I know you're coming off a period of time where that's a cute thing to say, but not very realistic when you got to get the offer in the next 10 minutes or it goes to somebody else. But we're leaving that period of time. And that even comes when you're entering listings in the MLS, right? Take your time, make sure the information you got is good and accurate. And we're going to come into a season of change. Don't feel like your industry is dying or leaving simply because how we share commissions is going to change, right? Be ready to learn and to adapt to the way things are going, and really kind of focus, especially if you're involved in committees at CAR and as these solutions, and you're part of teams that are coming up with these solutions to these challenges. Think of the consumer, right? Again, when we get together in a group, we're always talking about how to protect us and what's good for us as realtors. But the time is coming where for our industry to thrive and continue to move forward, we need to be focused on what's good for a consumer. And we need to write our rules that way. We need to write our competitive marketplaces that way, our forms that way, and make sure that consumers, are kind of front of mind as you're out there, servicing their needs, and that they take precedent, again, under the articles, the code of ethics, right? That the consumer comes first, and just keep that, kind of in the front of your perspective.
Okay, so just a final reminder, this has been for educational purposes only. No legal advice has been given by our panelists. But if you do have a legal question, Ed, I don't think you take clients, but John does. So contact John. And
yeah, I just built a pool, so I have a big empty hole in my backyard that needs to be filled. So, yeah, Tyler Birch, make sure you let them know you're asking for me, and they'll steer you to the right lawyer that can handle your matter.
But hopefully the information gathered here will keep you out of trouble and lawsuits. Thank you all. We're going to go ahead and end the panel today, or end the session. Have a good week, and we'll see you next time around. Thank you much.
See you guys.
And I'm gonna get you drafted that, Zorn, I'm gonna get you drafted that report
Okay,
tomorrow morning.
Appreciate it.
So let me know if you think it's okay, and I'll send it out the one we talked about.
Will do.
Thanks, Ed.
Bye-bye.
Talk to you
See
soon.
ya.